Welcome, everyone. My name's Karina Wang. I'm a clinical professor here. I also work with the first years. Yay, Amy from the clinic's also here. I also work with the first years in the legal profession program, our professional identity formation course, and do a lot of advising for students in the public interest spheres. I am very delighted today to introduce Samir Ashar, our guest from University of California, Irvine School of Law, who is one of the creators of the Guerilla Guides to Law Teaching. I'm going to leave that to him to introduce more and to talk more about himself as well. But we wanted to bring Samir here in part because in the past few years, issues of belonging and not belonging at the law school have become even more salient than they had been previously. And I think we're all eager to think about how we can bring some of the issues that are happening outside the law school, mirrored here in the law school dynamics, into our consciousness and our intentionality of how we teach and build our community, sort of both intellectually and socially. So Samir's going to talk a bit about how he's gotten involved with this work and what the Guerilla Guides to Law Teaching have to offer us. Samir?
Hi, thanks. Thanks to Karina, to the staff here for having me here and hosting me. I have to say that I come here with, I will try to exhibit it, but I certainly feel a great deal of humility and humbleness. I should say that I am sort of not predisposed to sort of diversity workshop type stuff, and I know that's not what I'm here to do exactly. But I grew up in an era when we had workshops at every stage in higher ed, and what I found was that it was a lot of talk and stuff kind of on the surface, but not really getting it at kind of deeper issues, structures, which I'll talk about both in the context of Guerilla Guides as well as microaggressions. And so anyway, I also should say that I come from a somewhat different environment at UC Irvine in terms of the makeup of our law school as well as the administration. So I think context matters, and there's sort of different approaches that can be taken in different places. So I hope what I have to offer is somewhat useful to you, and I look forward to engaging in a dialogue with you and to learning from you as well about things that you've tried or are thinking about trying, and hopefully in the kind of discussion period we can have more of an exchange rather than just kind of me talking at you. Before we get to that, let me give you a roadmap for what I want to do. So first is, as Karina said, I'm going to talk a little bit about the Guerilla Guides to Teaching. I'll explain what they are and what the goals were, why we did them, and give you some examples from them. Second is I'll talk a little bit about microaggressions and finding ways in which to abate, ameliorate, eliminate microaggressions in classrooms, in legal education, as well as in the community, law school communities more generally. I'm going to ask you to do some, as Karina said, parent share, small group discussion after that, and then we'll open it up to whole group discussion. Again, as I said, I hope that we can do some brainstorming together and have an exchange in terms of positive things that we can do to make changes in the context that we're in. Okay, so first, the Guerilla Guides. What is it? I mean, first of all, I should say, I didn't pick that name, the Guerilla Guides, so I don't think of myself as Che Guevara in the hills, coming down to try to take over Havana. A younger colleague of mine who is more bold than I am, I sort of grew up in a different generation to some degree, sort of suggested the name, and we picked it up and we've stuck with it. But the idea is really born of a desire for solidarity. I mean, that I felt all my life, growing up where I grew up, and then, as I said, in the places of higher education, the places that I've worked. And I have that in common with my colleagues. And I should say my colleagues who started this were a collective. Amna Akbar from Ohio State Law School, Jocelyn Simonson, who teaches criminal law at Brooklyn Law School, and Bill Quigley, who's a kind of legendary public interest lawyer and clinician at Loyola in New Orleans. And all four of us from different generations, really kind of three different generations, had a deep desire for building solidarity, both with the clients that we worked with in our work as clinicians or as lawyers, with our students, and then eventually with the social movements that we saw bubbling up in the places that we were. So for Amna, it came in through her involvement in the movement for Black Lives after the shooting of John Crawford in a Walmart in Ohio, in a town outside of Dayton, Ohio. She got involved in the local movement, the local student movement, and then she eventually got involved in Law for Black Lives, which is a sort of organizing force to try to bring lawyers to the aid of movement groups. Jocelyn was a public defender in New York City, and she was a witness to sort of the systemic injustice of the criminal justice system. And also, though, to community mobilizations, which, again, I'll talk about in a few minutes, that were occurring, for example, cop watching, or creating audiences in criminal courts so that judges and prosecutors were watched. And so she started thinking about that and writing about that. And then Bill had been involved in a variety of types of movements over his life up to the present day. So peace movements, sanctuary movement in the earlier days in the 80s and 90s, and then more recently kind of post-Katrina work, also racial justice and economic justice, other kinds of work that he's been engaged in New Orleans for a long time. For me, I moved to Southern California from New York about 7 years ago. And I was already involved in immigrant rights in New York. I was running an immigrant rights clinic. But I became a close observer and to some degree a participant in a really vital immigrant rights movement that was being pushed by dreamers, or post-dreamers, people who had left behind the dream label and were attempting to try to make changes. We're fighting their elders. We're fighting the advocates in Washington, D.C., and we're creating a new form of immigrant rights advocacy. And so I was really privileged to be sort of accompanying those folks and providing them with legal support and observing them, and some of which I've written about as well. So again, desire for solidarities across all sorts of lines, and observation of really interesting social movement activity that's ongoing, in different parts of the country in different ways. I didn't say what I do before I launched into the Guerrilla Guides. I co-direct the Immigrant Rights Clinic at UC Irvine. I also teach the first-year legal profession class, which is a combination of professional responsibility and kind of a sociology of the profession. And I'm chair of the Equity and Diversity Committee at Irvine for this year. And again, I'll talk about the Equity Diversity Committee a little bit in a few minutes more. So, Guerrilla Guides. The question that the four of us asked when we got together was, why was law school so divorced from the ferment that we saw in social movements? How could we build solidarity amongst like-minded law faculty across the country to start to change the discourse in legal education as well as the structure of our institutions? Right? And one foundational insight that I think we all shared was that social movements create law. They produce law. They produce change in law, both legal systems as well as both formal and informally. And yet, that discourse that was being generated from the movements that we were working with to some degree and observing was completely outside of the classrooms. You couldn't tell in a criminal law class that there was something called Black Lives Matter and that there was a serious critique and systemic critique of the way in which the criminal justice system worked. And so our idea was to try to capture some of that wisdom that was being generated, some of those ideas that were being generated, and find ways to work them into the curriculum. So I'll say four different kind of ideas, main ideas, a guide across the individual subject area guides, and then I'll give you examples of how each of those concepts plays out basically in different subject areas. So the four ideas that we're effectively advancing through the guides. One is bringing lived experience into the classroom. That is the lived experience of people in communities, people who are subject to law, clients, not clients, community members, activists, observers, into the classroom. Second, finding ways to critique and denaturalize concepts that we view as the received wisdom in legal education, right? From generation to generation, there's ideas that are passed down. I'll give you some examples in the subject areas in a few minutes. Third is expanding the boundaries of discourse in the classroom. It was our observation that we thought that most subject area courses basically taught in a kind of center-right discourse with the huge influence of law and economics over the last 40 years, a kind of systemic funding of law and economics and economic approaches to law really kind of having taken hold of classrooms across a range of subject areas, not just in corporate law, but really across the curriculum. And the fourth is, I've said it like a billion times already, and I'll probably say it a billion more times, finding ways to foster solidarity. Again, for our students with a community, as well as with other constituencies within the law school community, within the university community. Okay, so what do I mean when I talk about each of these ideas? So let me give you some examples. The first, bringing lived experience into the classroom. And I'll give you examples from the guides. All these guides are at, I feel like it's like an ad and it should flash behind me. It's like guerillaguides.wordpress.com. All the guides are up there. I think we have guides on like 7 or 8 subject matters, and I'll give you examples from the guides as I explain what I mean by these concepts. So how do you bring the lived experience of people in community into the classroom? So the criminal law guide was written by Amna and Jocelyn. They basically say they want to send students out to observe misdemeanor court proceedings, right? The way in which most people experience the criminal justice system, the kind of meet 'em, greet 'em, plead 'em system that is basically what constitutes criminal justice for a huge percentage of people who enter into that system. Having students have some orientation, understanding of what we're talking about when we talk about criminal law and criminal procedures. See how law doesn't matter a whole lot, but that there are all sorts of informal ways in which people are subject to systems through courts, particularly misdemeanor courts. Also, having students visit jails and prisons. And that's a hard one, and we can talk about that in the open discussion, because obviously we're not sort of aiming to be ethnographers, entering through the forest and kind of doing, kind of intervening in situations or contexts where, in a way that's not respectful or reduces the dignity of the people that we're maybe interacting with or observing. But we thought that it was really important. Jocelyn, Amna, and I agree with them, think it's really important to bring students into detention, jail, and prison systems, obviously because of mass incarceration and for other reasons. In the clinical guide, we talk about bringing organizers and journalists to class. So the idea is that lawyers have a certain view of defining problems in a way in which we think of how to attack problems. But there are other disciplines out there. Obviously, we know in the university there's lots of disciplines, social work, for example. But the idea also is to bring in that we've really tried to work on in all the clinics that I've worked on, is bringing in organizers, right? There's a discipline of organizing, community organizing that actually exists, right? Our former president was a famous community organizer. People made fun of it, but in fact, it's a complicated and interesting discipline with lots of different approaches. And so having organizers come to class talk about how they view problems, how they kind of define problems, how they attract people support to work on those problems together, how they generate solutions, we thought was an important intervention in the clinical curriculum. Journalists bring some of the same things, some of the same kind of qualities that we often don't see in law school classrooms. Bill wrote a guide on the use of lawyer biographies across subject areas. It's a list of like 24 radical lawyer biographies that he thought could be used in various contexts. Again, the idea is to try to show law students that there are people who came before who were trying to do some of the things that you may want to do. and that you are basically kind of continuing and extending a legacy rather than trying to figure out everything anew on your own. That's the idea of the use of lawyer biographies. Dean Spade wrote from Seattle University Law School, wrote the Administrative Law Guide, and Dean argues that it's important to have students enroll. So this is something we see a lot, sort of integrating experiential education into doctrinal classes. But in his case, what Dean did was had students work on comments to new regulations that were being proposed, but enroll as representing constituent groups that might be affected. And so the idea, again, is to try to have students begin to understand what it's like to view the regulations from the point of those who would be most affected. Second idea that we're trying to get across through the guides is the idea of critique and denaturalization. We do this in different ways. The Criminal Law Guide, Amna and Jocelyn talk about digging deeper into the context of appellate cases, looking for race even when it's not at the surface in the case books, and the way in which, for example, actually I can't give you a specific example, I don't teach criminal law, but Amna and Jocelyn do, and there are lots of examples in which cases are said to be about neutral principles, but in fact race is beneath the surface and not really brought to the surface by either in the casebook and then often not by faculty as well. In the clinics, it's being critical of the role of clinics. Clinics have been used by some law schools and some universities to ameliorate tensions between university and community, particularly in urban environments. And so being critical of the role of clinics and, the fact that it might be an instrument in some ways, and again, ameliorating tension rather than really bringing it to the surface and dealing with it. The other thing we try to do in the clinic is teach about multiple consciousness. So we're training our students to be lawyers in systems that are incredibly unjust, right? And so there's a kind of dissonance for students entering into the work. And they say, well, how can I both be a serious critic of a system and then learn everything I need to be the most excellent practitioner that I can be in the context of that system, right? So when we're training our students to go into immigration court is manifestly unjust. Everything is stacked against our clients. But the idea is you can have multiple consciousness. You can be good at the craft of lawyering and help your client use the rules to the extent to which you can to get your clients off or to get as low a sentence in the context of immigration as you can get. But you can also mount a serious critique of it outside. And you've got to have that kind of multiple consciousness in order to be an effective, I would argue, lawyer of any kind, public interest, private sector lawyer. You have to have a kind of multiple consciousness. Other ways in which we teach about critiquing and denaturalization. In the evidence guide, Anna Roberts from Seattle University Law School wrote the evidence guide and talks about understanding the asymmetric resources of parties and the way the federal rules of evidence play out differently and depending on the resources that different parties have. In a system in which courts rely on the adversarial system, when there's unequal resources, it means that there is unequal application of the rules in some cases. And so argues for an understanding of that in the mainstream evidence class. Another thing that Anna talks about in the evidence guide is critiquing the idea of relevance and prejudice, not critiquing, but denaturalizing it. Again, this is received wisdom. We think we know what those concepts mean, but for example, the example that's used in the guide is a police shooting of a driver in Cincinnati. It turns out that the police officer is wearing a T-shirt with the Confederate flag on it underneath his police uniform. And so in one court, one judge, trial judge, says that's relevant because it shows some injuries or lack thereof. Another judge says that's not relevant. In fact, it's prejudicial. And so what Anna asks us to do is to be thoughtful about what it means when we talk about relevance and prejudice and how that plays out, again, in different contexts, like the one that I just mentioned. The Human Rights Guide is excellent and long and filled with resources, and a number of different human rights practitioners participated in writing it. But one of the main kind of focuses of attack in the human rights context in the guide is on this savage victim savior kind of framework in which human rights work takes place, which I wasn't familiar with before, but like intuitively I was familiar with, but I didn't understand it was a huge idea within human rights law and human rights practice, and understanding that. Human rights law was rooted in a period at the sort of dusk of the colonial era. The fact that there were subjects in human rights law, that is the free people of the global north, and then there were objects, which is the unfree people, the poor people of the global south, and then there were savages. They were the sort of leaders, post-colonial leaders in the global south who were seen as really the enemies of progress and of liberation, and requiring the people needing saviors. And so the Human Rights Guide really takes that idea on and asks that teachers take that idea on in a sort of consistent way from the outset when teaching human rights law and doing human rights clinics. In immigration, a context I'm somewhat more familiar with, the idea of the reinforcement of gender norms and heteronormativity in immigration law. What we take for granted as immigration lawyers when we're seeking to do family petitions on behalf of clients, and the fact that the law reflects a very traditional understanding of the definition of family and doesn't really allow for alternative understandings of family. A few examples from administrative law. The meaning of notice in notice and comment. What does it mean for people who are actually going to be impacted by the regulation to receive notice? Do people really receive notice or do they not? Is it just a formality, right? So getting underneath it. Thinking about the impartiality of administrative process, right? We think that, post-New Deal, we thought that administrative law may be a safer place for vulnerable people. And in fact, we see that agency expertise, particularly captured agencies, actually use expertise in a way to further disempower impacted people and are subject to quite partial systems, and again, we see that in immigration law for sure, where the government and the judges, both two different branches of the federal government, deploy the law against our clients in a way that's again, manifestly unjust. So that's sort of the idea of denaturalizing, and there's probably lots of other ideas that folks have about how concepts that received wisdom that needs to be critiqued and questioned in mainstream law classes. The third idea is of expanding the boundaries of discussion, adding substantive topics. And I know, one sort of response to this is like, I have no time in my class. My class is filled. What am I going to take out to add these other things? But let's just, for the sake of conversation, let's think about some things that could be added. So in the criminal law context, the concepts of abolition of the criminal justice system that's being advanced by people like Allegra McLeod at Georgetown, and then non-lawyers, activists, Mariam Kaba, Rachel Herzing, doing really important work and thinking critically about abolishing the criminal legal system and mass incarceration. Focusing on misdemeanors, and this is work that's being done by my colleague Sasha Nadapov, as well as Isla Hauser-Kohler-Hausman, and a few others, are really focusing on the misdemeanor system rather than being focused on solely on felonies, which most of the case books are focused on, because that's the way in which the vast percentage of people really interact with the criminal justice system. Some other issues: police violence, prosecutorial power, which I know most criminal law classes deal with, but in a deeper way, because there's so much power that's deployed by prosecutors in the current context. Stand your ground laws, right, that have come to the surface, the killing of Trayvon Martin and other contexts in recent years. In the clinic, we talk about diversifying the subject matter that we talk about. Really, I think as a clinician, the main way in which to do that is to alter our intake techniques, because the cases basically form the subject matter that we talk about, right? So if you're thoughtful and you do your intake based on a sense of mission, then you're going to bring certain kinds of subject matters into the clinic, and it's going to inform the entire experience for students. So one way in which you can alter your intake is prioritize issue areas and cases in which there's some kind of community mobilization, some kind of community organizing ongoing, right? That changes the kinds of cases that you might bring into the clinic. They might be less less pedagogically safe, but they might actually result in learning that is deeper and more important over the course of law students' careers. So they're kind of less obviously pedagogically understandable, but they're, I would argue, important over the long term, both for the development of the clinic as well as for the development of law students. Another thing, one of my pet peeves is cultural competency, which is funny because I'm the chair of the Equity Diversity Committee, and I think a lot about diversity and inclusion. But there's a sort of the received wisdom in clinical teaching from some of my mentors is that you can teach cultural competency, and I think that just needs to be criticized and questioned and thought critically about. That is, there are some times when you cannot communicate competently across lines, potentially, right? And you need to kind of think of other ways in which to wage those relationships. Or you need to bring third parties into the lawyer-client relationship, like interpreters, organizers, pastors, in order to make those relationships work. And that's not something that's unacceptable. We need to find a way within the bounds of the professional rules to make stuff like that happen. Evidence, some examples from evidence. The idea of credibility and the way in which criminal records are used as a proxy effectively for race and credibility determinations is an idea that Anna spotlights. Also, forensic fallibility. The idea that forensic law isn't, end-all be-all, and that there's lots of evidence, particularly in recent years, DNA testing, other examples of ways in which forensics fail parties in particular contexts. I'm running out of time, so I'm going to jump ahead a little bit. In the immigration context, immigration law, there's a guide, and the idea is including things like the Middle Passage and Indian genocide in an immigration law class, because those topics are there's forced migration in one case, and then there's eradication in another case, and then forced labor in all of those. That really drives the immigration system from its earlier days to the current context. Dean does really interesting things in ad law, having students do mini case studies in different areas of administrative law that are not usually featured in ad law casebooks. So, focus on corrections contexts, a focus on child protective services in urban areas, immigration enforcement, welfare, the Bureau of Indian Affairs, all ad law contexts that, again, don't get a lot of attention in the casebooks. The final idea that I talked about earlier is the idea of fostering solidarity. And I've already talked about this a little bit in the context of, really across the context, where are people organizing and agitating, right? And trying to bring that subject matter into the classroom. And that works for clinics, as I said, in the intake context. It works for criminal law in the context of, cop watching and other efforts to democratize the criminal justice system and open it up and make it less opaque. As well as in human rights and immigration law, right? Again, looking for where people are organizing and agitating and trying to bring the subject matters that they are paying attention to and the critiques they have of the system into the classroom, into the kind of mainstream of legal education. Okay, so that's the Guerrilla Guides. That's my sales job on the Guerrilla Guides. And you can take it or leave it, and I really invite your comment on it. Please take a look at them if you'd like to. It's online. And we're not selling anything, so it's all free. The idea of, I wanted to talk for a few minutes about microaggressions and the presence of microaggressions in different contexts, and then I'll transition into our discussion. I'm going to start with what we do in the Immigrant Rights Clinic and how microaggressions comes up, and then I'll translate into the law school context. So we use an article by Peggy Davis, who's at NYU Law. She wrote an article called Microaggressions, I think. I forget what the full title is. But the question that Peggy basically asks is, how does structure inform in relationships and individual interactions, right? What's the dialectic between the structure of particular contexts and the way in which people interact with each other? And so what we ask our students to do when we ask them to do the court observations that I was talking about earlier, we ask them to go to immigration court and do an observation. And what we want to learn from them. Okay, were there examples of microaggressions that you saw between lawyers and clients, between lawyers and interpreters, between judges and client or families? What are the relationships that you're observing, and how does that help you understand what the underlying structure and distribution of power is in that particular context? So that's how we use the microaggressions framework. We don't want it to end with the observation of a microaggression. We want it to end with a deeper kind of examination of the way in which, again, power is distributed in the context, and how hierarchy and power kind of gets deployed. Because it's I think Professor Davis's idea, and the idea that we tried to talk about in our clinic class, is that these systems of hierarchy and power distribution generates individual interactions that are that embody disrespect, indignity, injustice in different forms. So yes, it's important, we tell our students, to make interventions in the moment. That is, if we ask them, if you're the lawyer in that particular context, what would you have done to change the dynamic when a judge wasn't having an interpreter interpret immigration proceedings to your client? What could you have done differently in that context? What would you do if you were in that context? That's a little bit more than a microaggression. It's a lack of due process. But what do you do in the moment, right? But then the other question is, how do you change the structure and the incentives that permit those microaggressions to occur? And I would transpose this sort of critical questioning into the law school context. How does the structure of law schools and legal education inform our relationships and the individual interactions we have with each other? And I would say that there are certain characteristics of law schools and legal education that most certainly determines or creates an environment in which there will most certainly be microaggressions. So hierarchy, right? We have hierarchy across constituencies within law schools. And one of the, between students, faculty, staff, community, clients. But then there's also hierarchies within these constituency groups. So there's lots of hierarchy within faculties, as you might know, in terms of the different kinds of statuses that we have and that we're given by the institution. So hierarchy is a kind of core feature of legal education that we need to start to think about if we're going to talk about microaggressions. Another characteristic of law schools and a lot of higher ed institutions is opaqueness, lack of transparency, a lack of understanding, right? And we see this in the older ways of legal education, this sort of paper chase stuff, hiding the ball, that kind of thing. But then you see it also in governance within law schools and, again, other institutions of higher education, where it's unclear why decisions are being made, who's making them, who's a part of the decision making at all different levels, in all sorts of different kinds of decisions, how deans are chosen, how courses are taught, who gets to teach courses, how are exams given, all sorts of questions that are important to all of us, particularly to students, are kind of, in a black box, basically, and hard to understand why things happen as they do. Then in that context, in legal education, as in other contexts, particularly in higher education, as I said, the diversity workshop, we make ameliorative gestures in the face of structural exclusion. So, we have committees, we have workshops, we try to kind of allay people's dissatisfaction and concern about issues, but we don't really deal with the core fundamental issues, the underlying issues. And so here's some sort of structural interventions that could be made that might contribute to building an environment that would be less prone to microaggressions. And I offer all these humbly. Part of this comes from my work as chair of our Equity Diversity Committee this year. And they're all works in progress. But here's some ideas. So one is changing the content of classroom coursework, right, which is all the stuff I just talked about in the context of the Guerrilla Guides. Second is creating a committee that, what we've tried to do at Irvine is creating a committee that is an actual forum for people's complaints, thoughts, ideas, interactions, reactions to things that take place, but then giving the committee some degree of authority and some consequences, some actual governance consequences for that stuff being fed into some kind of committee, but then the ability to affect the ways in which things work within administration or with faculty. One thing that we did on the committee this last year, we chose a new dean. We have a great new dean. Her name is Song Richardson, and she's a criminal law specialist. But one thing that we did in the course of the dean search was attempt to send questions generated by our committee, which is a committee made up of staff, students, and faculty, to the dean search committee to ask questions in the screening interviews. They probably didn't ask the questions that we asked them to ask, but we sent them like 3 pages of questions, right? And there's like half-hour interviews. But the idea was to try to make some kind of impact on their consciousness. We had good people on the dean search committee, so we were okay. But we wanted to try to assert some degree of committee agency in that process. We're attempting to change faculty evaluations, and this is going to be really controversial, and we're just starting, but just adding a question on the faculty evaluation that asks about whether or not the teacher promotes an inclusive learning environment and raises issues of bias and stereotype in the law. It's very controversial, from friends and foes on the faculty. There are questions like this in some faculty evaluations at some higher education institutions, but in some way that changes. And the reason it's controversial and it's threatening is because it changes incentives. It changes the incentives of faculty. It challenges faculty. The first response faculty have is, you can't tell me what to teach. This impacts content. Okay, that's true, and that's problematic to some degree because of academic freedom. But there is a real intent to try to alter incentives in the promotion and tenure process to take these kinds of issues into account and the sensitivity of teachers to these issues. And then finally, finding ways for students and staff and community and clients to have agency in the governance mechanisms in the law school in a concerted way, in a consistent way. Again, completely a work in progress. And attempting to find roles for students. For example, we have curricular reform coming at Irvine in the next year or so. We're going to revise and revamp the first-year curriculum 10 years out from our founding. And the question is, there's a playbook for doing curricular reform. You have a faculty committee. It's all faculty determined, right? Maybe you consult with some alums about how to better prepare students for the employment market, but that's about it. But you don't really listen to students so much because they're just passing through, and they may not know so much about informing the process. And you certainly don't listen to community or other people who think of the law school as a constituent part of the environment. That's important, and that what is taught in classrooms might, in some way, modify the law school's relationship with community. So identifying ways in which to elevate, again, students, staff, and community agency. Another big initiative we've been working on this year is staff agency. That is staff. Turns out staff were the unhappiest constituency at the law school. We have like sky-high satisfaction ratings among students that we're always tweeting about and stuff like that, but that when we get the same surveys back from staff, they're really angry. They feel like there's no opportunity. There are only entry-level jobs and no way up. There are people who, and there's very little knowledge and interaction. That is, faculty don't know staff. Faculty are seen as the sort of, the kind of heads of the institution and completely ignorant of what's happening in the rest of the institution. So really an attempt, so we did focus groups with groups of staff, and then we're going to attempt to carry some of that messaging back to the faculty as well as back to senior administration. So those are some sort of structural ideas. I'll just say, I went way over my time. I'm sorry, you're tired of listening to me talk. But, interventions in the moment when you see a microaggression, I got to say, I'm not so great at this as a teacher or as a person when you see it happening, because I tend to want to, sink back but it's essential to not do that. And like we teach our students about being a lawyer in an immigration court and saying something when they see something unjust happening, it's their professional duty. Arguably, there's something similar that should apply to each of us as human beings. There's a quote from a Martha Minow article, who's a former dean of Harvard Law School. She says, "Where you stand is what you see." right? So if you choose to stand in certain places from certain viewpoints, then you're going to see things. You're going to see microaggressions that you might not see if you don't stand in that standpoint, in that position. And so it's essential to kind of force yourself to put yourself in different kinds of sort of situations in the power hierarchy in the context that you're in. And then to offer mutual support. And it may not be in the moment, it may be afterward, to other students, to other faculty, to staff, to indicate some degree of sympathy and some anger, if that's what you feel, whatever it is that you feel. As a professor, I think, again, definitely a work in progress for myself, is trying to naturalize a kind of inquiry-based discussion in the classroom, naturalizing intellectual and political conflict, not being afraid of conflict, but safeguarding people's personhood, right? That balance. It's like, okay, let's talk about, so in legal profession this year at Irvine, somebody said, I don't believe that white privilege exists. So let's talk about that. What does that mean? What does white privilege mean? And let's talk about it, though, not in a way that makes people of color feel like they are not part of the community, part of the classroom discussion. But let's engage. We can have a conflict. We can sort of try to naturalize that and talk about it. But again, in a way that keeps people safe or makes people feel safe. Okay, so those are some ideas I had, both structurally as well as in the moment. I think that maybe we should just open up to a broader discussion. What I was going to ask small groups to talk about is what's a structural intervention in the context that you're familiar with that might prevent microaggressions in the classrooms and in the law school community. And maybe people can, if you have ideas about that, you can offer that now to the group in the discussion section, if that makes sense. But I'm happy to hear your ideas, your comments, your questions about anything I've said or even anything else that you'd want to talk about. Yeah.
So I'm curious about, as students, when we look to professors that are implementing these techniques,
yeah,
if it is just one or two classrooms that we're seeing that in, we run the risk that that's just going to become like the token classroom where this is acceptable to talk about.
Yeah.
And it becomes taboo outside of that classroom because that's the space where these conversations happen.
Yeah.
So as students, do you have ways that we can either engage our classmates or engage other professors to try to get a critical mass of these conversations to occur?
Yeah, it's a great question. And I mean, I'll say that that's our intent, is to get out of the social justice sort of part of the curriculum, right? Clinics are usually seen as the repository of social justice work, social justice warrioring, whatever you want to call it, and then some critical theory classes, critical race theory, critical feminist theory are usually seen as the sort of, that's where that stuff happens, the way you're describing it. And the idea is to try to bring some of these ideas into the other classrooms, into the the sort of bar courses, the doctrinal courses. Now, the strategy with individual professors, I can't say that, right? But I have to say that it takes faculty allies. Maybe faculty might listen to other faculty, potentially, in some ways, in ways that they wouldn't listen to students. And then the other thing I would say is that there can be self-help as well. That is, there are materials that are available. There are critical materials that are available in all of these subject areas. And I know y'all are like already busy just trying to master the stuff that's in the syllabus, let alone adding additional materials to the syllabus, right? But things like reading groups, you can try to get credit for a reading group, right? That would give you a little bit of space in your schedule. I don't know if that's possible or not, but that would actually give you. You could find a faculty member who's willing to sort of give you independent study credit, and then read some of the stuff that's out there that's, again, critical, particularly in the first year curriculum, but across the curriculum. With like-minded students. And I don't think the goal here is to convert everybody. It's more just find your people, right? And then find time to interact with each other and to bring some of this material that's out there in communities, in the intellectual, sort of ecosphere, into your learning with each other, and then build out from there, is what I would say. Other thoughts? Yeah. Hey, Jeannie.
So, how I respond to that additionally is that if you see something, say something about this. One of the things that students don't understand about our classes, we have no idea really what's happening with you, right? We don't know what happens in the rest of our colleagues' classes. We don't know how you may have perceived something that we said. So say something to faculty members that you find to be accepting of the argument, whether you have them in class or whether you don't, because we can't do anything if we don't know, right? All of the people that have had incidents happen in the class, we know them, right? And we've known them for a long time. And some of us are not afraid to say anything to them. Say in the most gentle, kind way possible, hey, I bet you didn't realize that this happened in your class, and I know you to be a really nice person, but this is how the students felt about that particular thing that happened. And let's strategize about ways that we can deal with it the next time that comes up. That's how I've seen it dealt with productively over the 100 years that I've been here.
I think that the issue of students are saying something, and in our case at Irvine, staff were saying things that weren't being heard by the institution, and so the question is, what are the forums, what are the portals through which that information will be conveyed? And you're suggesting that it should be potentially to faculty that you might think of as sympathetic or might offer some degree of understanding who could then convey a message. One thing we've talked about is creating like an anonymous portal online through our student services office, but we're sort of leery about that because if it's anonymous, then you can't really investigate the thing that's brought up. But it does offer safety to people who may not be willing to come forward, don't feel like they have standing to come forward, or feel in some way in danger, particularly when you're being graded by people. That I think that requires some degree of brainstorming. Is what are the paths? How are you going to convey information up and into the sort of the people that you think might act and do something? I'll say one of the things is that we've just done some workshops, along the lines of what Professor Bell is talking about in terms of how to talk to colleagues about instances where we actually did case studies based on things that actually happened, and then we talked about it in small groups. But that required grace on the part of the people in whose classes that occurred. Some of them were there, and they were in those cases. For the most part, there's a whole group of people who aim to be not to be offensive, right? But are trying to do the right thing, and they may be open to some of those approaches in a way that we found than others. Sorry, go ahead.
Okay, so I can't believe I'm actually going to talk about this because it's hard. It's difficult to talk about these topics, in a classroom. And so I teach in a clinic. And generally, people who want to be in my clinic kind of self-selected. So I don't know that I have all the problems that you might have in some of the bigger classes where it's people are more randomly assigned. But I will say that over the years, I have had one example as a guest speaker. Carmina knows what I'm talking about, who said something in a class that I didn't expect to come out of that person's mouth. And there were about 10 students in the room. And I would say about 3/4 of them found the comment to be very racist. I don't think the comment was intended to be racist, but it was perceived as quite racist. And as those words came out, and the class was very mixed, okay, and it was it had to do, I can't really, just because I don't want to get into specifics, I would say that there were a number of minority students in the class, and you could sort of feel like the words came out, and from my perspective, the words were like in this bubble, and I was trying to think of what to do, and it is not easy in that moment to, what are you going to do, right? And as I was trying to think about what to do while the words were hanging in the air, one of the students raised his hands and said, I'd like to talk about that, which was fabulous. We spent the rest of the hour talking about what had happened, why the person had said it, why the person felt and that person's discipline. It wasn't a racist remark, whereas I would say almost all of the law students felt it was racist. We talked for an hour, the guests left, we had a role play coming up at that point, and so another mediator, our teaching mediation program, came, and we really were not done with the conversation. In fact, we didn't have a role play that day. We kind of dissected what happened. And it was a huge learning experience for me, and I think for everybody involved, and I hope for the person who made the comment, who like I said, I don't believe to be racist, but there was no other way to interpret the remark as it was made. And since then, people have made comments occasionally. Sometimes it is a student, sometimes it is a visitor, and you don't have control over what people are going to say. And part of the challenge, I think, for someone, for the faculty member, is to make sure that while you are trying to deal with a situation where there has been what you perceive as a microaggression, or if you perceive it later, because sometimes sometimes I don't perceive things as they happen, but I perceive them on reflection, or somebody hits me over the head and says it. You have to think about everybody's feelings in there, and so it can be a really difficult issue. I appreciate as a faculty member, if it isn't raised immediately, but you're stewing, that you just come and talk about it, and talk about it, because then there are constructive ways of dealing with it. If I don't know how to deal with it, usually I hit up Karina on how to deal with it. But honestly, think about it, because I think most of your professors are well-intentioned, and some, as my daughter would say, are more woke than others. I can't believe I used her word, but I am using it. And we all try, but there are times, and when you're feeling upset, sometimes you can raise your hand and say, I find, I'm disturbed by that comment, and hope to give that professor a chance to start a conversation. And if they don't, follow it up a bit. Or as Janine said, go and talk to somebody and who you find who is friendly. The goal is to try to, in the real world, you're going to have to sometimes deal with these situations. And really, this is a place where I hope to God it is safe enough for you to talk about things that disturb you. But remember, everybody's on a journey, and so you've obviously done a whole lot more studying of this topic, Samir, than I have. But obviously, these are things that we want to do right by our students. At least most of us, I think, do. And so make sure you're communicating with us, because I would rather hear directly from a person who's been affected and try to fix it than I would rather hear about it than hear somebody go and complain to someone else who comes to me, because I'll feel like then I haven't established the right bond with my students. So I say give people a chance. If we fail you, well, then I understand. Then you have every right to go wherever you need to go, but give us a chance to try to fix whatever doesn't quite go right in the classroom.
Thank you for sharing. I think that there's all sorts of reasons why people don't speak up, and I think it's the job of the institution to try to think about ways in which to change those underlying reasons. That's what I talk about when I'm talking about the structural interventions, to try to find ways for it to be safer for people to speak. Other thoughts? Yeah.
You mentioned that you got this feedback from staff that they're the most dissatisfied group. And I'm wondering, I think it's one thing to go to the classroom and address students because that relationship is already pretty well established. What are the strategies for addressing staff concerns?
I think, again, lots of stuff I'm saying is work in progress. We're trying to figure it out. But, so for example, the question on the survey that staff were, exhibited the greatest unhappiness with is the idea that they were learning and kind of expanding their own professional development by doing the job function that they were doing. And so, there are things that institutions can do to make it. So, for example, my faculty assistant, graduated with an undergraduate degree in art history. That's what she really, would want to do if there was money that could be made in that area. And so one thing the institution can do is try to open up courses, on campus for staff who might want to try to partake in some of that, and the kind of benefit that they don't have access to, that it's only faculty, maybe faculty families that have access to. But that's that's one kind of intervention. I mean, our staff actually on their own started a reading group. And they bring faculty in to talk about issues. So I forgot what the first book was. It's a legal reading group. So it's like different books having to do with legal concepts. And they brought a constitutional law scholar, federal court scholar, to talk to participate in the reading group. And the idea is to see people as equals, as intellectuals, as people who have ideas about things. That is, they're not just silent technicians that are, kind of basically facilitating faculty to think big thoughts and students to kind of gain skills, graduate, and go onto the market. That's kind of the philosophical approach that an institution needs that shift needs to be made in order then to generate lots of ideas about. There's like a million things that you can do to try to make people feel like they're more invested in the institution, and that they have the ability to learn and to expand their horizons in their work at the institution. Those are just some examples. The first thing is listening, and also abating subordination to the extent to which there are faculty who are basically, I guess I'm sharing, what's that word? Sharing secrets out of school. I forget what the saying is. But, there are faculty who are horrible to faculty assistants. Sending a message that that's not permissible, that people have to be treated with dignity up and down the institution. Other thoughts? Yeah.
Another thing that I know a lot of, at least I don't know, it's a common concern among at least one else, and probably for all law students, is when you go into one of these bar classes and you're presented with things that the student knows not going to be a bar, there tends to be this, okay, well, I can check out this at 20 minutes. Changing that culture is very difficult.
Yeah.
And way down the scope even of this career conversation, but how would you sort of suggest changing the incentives, not just for faculty, but for students who are sitting in this to pro or contracts or whatever, to begin to convert?
That's a great, tough question. I was at CUNY for 8 years before I moved to Irvine. And at CUNY, we had a problem with bar pass. Like, we were trying to get our students through the bar, and we, before I got there and while I was there in the early years, we were pretty low. Now they're doing great. And so that was a fundamental issue. CUNY was founded as a critical legal education school, critical pedagogy, preparing public interest students and creating access to the legal profession. But we were also trying to get our students through the bar. And so that kind of pull, was very present. And the temptation was to get rid of all the critical stuff and just focus on the black letter. One thing I'd say, maybe this is more of an intellectual response, is that critique helps you understand the underlying doctrine. That is, if you feel intuitively critical of a concept that's being deployed, you're going to want to learn it to understand why it doesn't work, would be the argument. So that may not come in the actual class itself. Maybe the class is more about black letter, but then in sort of an add-on, 1 credit, or an independent study, or some other way in which to engage with material that I would argue actually doesn't prevent pickup of black letter concepts, but actually promotes it ultimately. But again, that's kind of an intellectual response. I think the fight for professors and for students is like, I have limited amount of time, and what am I going to teach in that time? And that's really real. I'm not going to discount that.
Thank you very much for your report.